So on to our guests. Now our first guest tonight, not practicing of course back in 1949, but still, has for over 30 years earned himself the title of one of the most influential lawyers of our time, often described as one of the great defenders. In 2009, he was the winner of the LAPG Outstanding Achievement Award, and he's really effectively helped shape and mould the law in a range of areas, including changing the way in which children should be tried and helping to abolish death penalties in some of the Caribbean countries. Responsible really for many of the changes that have affected prison law, particularly over the recent decades. Also has represented some of the country's most unpopular figures, including Myra Hindley and Abu Hamza. He really is, in every sense, a champion of the underdog, and is still very grateful that he's given up time to come here tonight to encourage young lawyers to follow suit. So this is the patron of the young legal aid lawyers, is of course Edward Fitzgerald QC. Two or three of the most important publicly funded cases which you've worked on over the years.
Good evening, Frank. I'm very honoured to be here with the young legal aid lawyers, and just to say, well, there's a case called Anderson I thought I'd start off with in 1983, some time ago, which was about the right of prisoners to have access to solicitors to sue the prison authorities. And in those days, and it's quite reminiscent of what's happening now, you couldn't get out to a solicitor unless you first made an internal complaint, which you could then be prosecuted for making a false and malicious allegation against the prison officer. So that tended to deter people from making the complaint and therefore stop them going to solicitors. And Anderson had been beaten up during a disorder in Wormwood Scrubs, and he challenged the rule that required him first to disclose why he wanted to see the solicitor, and secondly to make an internal complaint. And the courts upheld his challenge and said that that was an interference with his unimpeded right of access to the courts. One of the important things about that case was they said the Home Office argument was, well, if you really want to, you can send your own writ to the High Court. You don't need a lawyer. Do it yourself. And so the Divisional Court said in that case, no, it's ridiculous to expect prisoners to have to formulate their own proceedings. It's reasonable to expect that they need a lawyer to help them, in fact, burn books. And so in the light of some of the things that are now being said about you don't really need lawyers and you've got to exhaust your internal complaints, I think Anderson case is quite an important one. Of course, led on to lots of other cases about the right not to have your correspondence with solicitors read, not to be stopped for being over long or obnoxious in the Leach case, and then, of course, finally, the right of access to journalists to be unimpeded where you're complaining about a miscarriage of justice. So part of that development of prisoners' rights cases. Well, time for another one?
Yeah.
Well, the other one I just thought I'd mention is because, again, legal aid was originally refused in this case. Venables and Thompson, the people, the young boys convicted of the Bulger, killing of James Bulger, they were originally refused legal aid to challenge the 25-year tariff fixed by Michael Howard after reading the Sun newspaper's demands for an all-life tariff, when he said I took into account the petitions from the Sun in reaching my decision. The legal aid authorities originally said there's nothing in this, 25 years is entirely appropriate to get lost, and it had to go to appeal in order to get the legal aid. But then I think that case established two really important principles. One, that when ministers were taking quasi-judicial decisions, they shouldn't do it by reference to public opinion, or certainly the Sun's version of public opinion. No, I have great respect for the Sun. And the second one was, the second principle was that you had to approach fixing a tariff or punishment for children completely differently from adults, because before that, there hadn't been that emphasis in the tariffs fixing, and indeed in the courts. And the House of Lords really revived the welfare principle, paramount in dealing with young offenders must be concerned for the welfare and rehabilitation of the child. That case, of course, then went on to Europe, and the European Court said it had to be fixed not by the politicians but by the judges. And eventually, when the tariff was fixed by Lord Wolfe, it was fixed at 7.5 years rather than the 25 years originally fixed. And then another example of legal aid would be the final stage in that, when they came out, or when they were about to come out, the need to have the lifelong anonymity order. And again, without legal aid, it would have been impossible to establish that principle that they are entitled to the protection of anonymity, which of course has been repeated for Mary Bell more recently in the Maxine Carr case. So all those unpopular cases would not have been possible to get that protection without legal aid.
That's wonderful. And so, over your years, you'll have seen huge changes in funding and also law, including, of course, the Human Rights Act itself. So I wonder if you could say a few things about how you see legal aid playing its part in any healthy democratic system.
Well, it really follows on from what I've been saying before. I'm sure everybody here knows that really, certainly the people who I tend to represent are sort of dispossessed and unpopular and marginalised type of people. You know, they need prisoners, mental patients, asylum seekers, that kind of client is not popular with the politicians. They're never going to get votes, and giving and upholding their rights is seldom going to be at the centre of parliamentarians' concern. Their only hope is in their human rights being asserted through the courts by themselves and with the help of lawyers such as yourselves. And therefore, legal aid is essential in order to get access to the courts and to help these people to formulate their claims. And children, of course, particularly so. I know that very much a cause young legal aid lawyers is taking up, Laura James particularly. So that's the reason. It's really that these people, because they're unpopular, aren't going to get assistance from elsewhere than the courts on the whole, and they're not going to get to the courts without lawyers and without legal aid. And there's nothing more sinister, really, than the current thing where the government is saying, we don't want money spent on these unpopular people, we're going to cut legal aid to them.
And in the light of that, what advice could you give to aspiring young legal aid lawyers of the future then?
Well, I've got to say, I'm probably not best placed to give any advice other than stick with it. I took about 3 times to get 3 pupilages before I got tenancy, and I kind of ran off to working as a drama teacher in a ball school before I finished. And so I'm not a very good example of how to get better. I think if you just stick with it, you always, you know, for those that are doing barrister, you know, you will eventually get there, and don't be deterred by the horror stories. Secondly, I think, and again, I know that I'm preaching to you, but it's certainly worth it. There's nothing more wonderful than working for people's rights, and indeed, I think the sense of working with other people, particularly in the big test cases, working with other people and not doing it alone. And then finally, join the Young Legal Aid Lawyers Association. The moral is, don't be miserable and individual, worrying about your career. Get in there with the team and work. You know, I mean, not that I ever took that into that thing, but I'm learning gradually that you get nowhere unless you work with other people and in a cooperative way. And I think that's why organisations like this are fantastic, and I really am very proud to be part of it.
Thank you very much.